It really does, Stephen. That was a quick 15 minutes for me too. I don't know what happened. All right. Oh, speaking of that, I got to close Outlook, which I never even looked at. Okay. That was 15. It's true. All right. I know. It's the same thing for me, Stephen. It's just nothing but answering. In my case, I didn't even get to email, just answering messages on Slack. All right. So do we have any questions about this? Any questions at all? All right, perfect. That's true. That's a true story. Okay, beautiful. So now we're going to look at beneficiaries of a trust. Now, I think what we're going to do here is use a particular application. Oh, now, Sean, you've just, no, who's Sean? Sorry. Oh, that's Sean Pichet. Sorry, I apologize, Sean. You've never logged in with your iPhone before. All right. Who's Sean? Who's this Sean in our class? And you're gone for 3 minutes, and I literally forget who you are, Sean. Eh? So, okay, so it's all right. So the yeah, in order to look at trust beneficiaries, we're going to look at a particular kind of trust, and I think this is helpful. We're going to look at a family trust. Okay, and family trust is used quite a bit in farming. And we see it used other places too, sometimes with a successful small business. Okay. And the gist of the family trust is usually that we're trying to keep an asset in the family. Okay. There used to be more of a tax planning opportunity here. You don't get much tax planning opportunity with family trust today, although I'll show you how you may be able to. Okay, so here's what we've got. Got Dennis here, and Dennis owns shares of a small business. He's got $2 million of pref shares, and he's got, let's say, $3 million of common shares. His pref shares have an ACB of $2 million, okay? But his common shares have nil ACB, and he has the lifetime capital gains exemption available. Okay, he's never used any lifetime capital gains exemption. So that's his whole setup here. Okay, all good. And here's what he's going to do. He's going to, while he's alive, so Dennis is alive, this is what we would call an inter vivos trust, meaning he settles it while he's alive. Inter vivos is Latin for between the living, just like we all know, right? So we're going to have an inter vivos trust. And he's going to settle all of his shares into this trust. So what happens when he does that? What happens when he moves those shares of his business into the trust? They're deemed disposed. So on the pref shares, of course, ACB is the same as the market value. There's no capital gain here. Okay, but on the common shares, of course, we're going to have a $3 million capital gain. Now, what's he going to do to partially offset that capital gain? So he's going to use his lifetime capital gains exemption. He'll use $834,000 of lifetime capital gains exemption. So ultimately, he's going to have $2,116,666 of cap gains that he actually has to pay tax on. That's right. And now the family trust will inherit the shares. So the family trust now is the owner of these shares. Okay, so we'll call this thing the Dennis Family Trust. And the question then, so we know now the capital of the trust, right? The capital of the trust is going to be those $2 million of preferred shares. And they're going to have a $2 million ACB and $3 million of common shares. And they're going to have a $3 million ACB. Would everybody agree with that? Yeah, he's got to have some other way to pay that capital gains tax, Todd. However, he does it. So maybe he has some other shares he sells. He might just have some cash laying around, whatever it is. He's alive, so there's no life insurance, right? Yeah, you got to have some cash to pay that. There's no easy way to do that, but it'll get done. Now, I'll point out that this is a QSBC. It has to be a QSBC. So that means it's also CCPC, okay? Which means that TOSI applies, okay? So that means that we can't just artificially use this as income splitting, and Dennis is not yet 65. Okay, that's all good? Because once he's 65, then at least between him and his spouse, TOSI no longer applies. Okay. So now we're going to name some beneficiaries of the Dennis Family Trusts. My first beneficiary is going to be Dennis himself. Okay, and I'm going to name Dennis as a beneficiary, but I have to be careful here, okay? This cannot be what we call a revocable trust. So if this is a revocable trust, which means that Dennis can resume control at his discretion, then we really don't have a trust anymore, okay? So if we make it revocable, that is if Dennis is the trustee as well, then we have a revocable trust. And if it's a revocable trust, then any income is attributed to Dennis. Okay, that's good. So all income is attributed to Dennis. And if Dennis gets sued, there's no protection from the trust. There's no protection based on the trust arrangements. Okay, that is a lawsuit against Dennis could fully access all of the value of that business. Okay, are we good there? But we are going to make sure that those things are not true. We're going to make sure it's not a revocable trust, and we're going to have Dennis as a beneficiary. Okay. And then I'm going to have, let's say, Dennis's kids as beneficiaries. Okay. And I'm going to have Dennis's kids' spouses as beneficiaries. Not everybody likes this. Okay. But this is how I would normally do it. I prefer this arrangement. I think it's the better way to do things. If there are any grandkids, or if it's likely that there would be, then I would also name the grandkids as beneficiaries and possibly their spouses as well. Okay.
Jason, can you name grandkids that are possibly coming, like
Yep.
future? Okay.
Yep. So if Dennis had, so the rule around this, it's complicated. Okay. It's complicated, but the rule here is generally that if you have a child who is at least age 14, that there's a strong enough likelihood that that person would have children of their own one day that you could name your prospective grandchildren. Sorry, Betty, yeah, I'll bring Dennis's spouse in too. Sure, yeah. Okay, so I've got Dennis's spouse also as a beneficiary. I can't just name a flat out per stirpes distribution here, Shauna. That doesn't, so per stirpes is really, remember, a gift over provision, right? Per stirpes kicks in when somebody has died, and then we have to figure out whether we're bringing their heirs into the discussion. Yeah, okay. So I'm going to name this whole raft of people. And for the most part, I have to name them fairly specifically, okay? So the kids, I probably don't just want to say Dennis's children. I probably want to name the children. I probably want to name the spouses. And if the grandkids exist, I probably want to name them. If they don't exist, then I probably just use a class of beneficiaries here. All right, that's really going to come down to the lawyer. The lawyer should be able to tell you why they have chosen the beneficiaries they did. Okay. Everybody's with me here so far? Then I'm going to have a trustee. Now, my trustee, this might be a professional trustee, like I had mentioned previously. I forgot to look up my trustee fees at the break. But anyways, it is fairly expensive. It's going to cost you at least tens of thousands of dollars a year, typically, to use that kind of service. But I'll find them at the lunch break then. So we have professional trustee. We can have, we might have the board of directors of Dennisco, or whatever the company is called. Okay. We might have whatever Dennis's adult children. Okay. But what we don't want it to be is Dennis. Okay. Don't make it Dennis, because then it's revocable, and then we're going to have a whole bunch of other problems. Okay. That's all good. Essentially, if Dennis is the trustee of this thing and it's revocable, then we've created what's called a bear trust, B-A-R-E. Okay. And the bear trust really means that you can, no, it's inter vivos. He did this all while he's alive, Todd. Remember I said between the living? Okay. So if it's if it's a bear trust, it really means that there's only sort of at the most basic legal definition of trust, but not really in the end do we have a trust that's going to stand up to any scrutiny. Okay. This is all good. So what I've done here is I've got no actual tax benefit, at least not right now. Any income generated by the trust is going to go to Dennis. Okay. Yeah, exactly, Rosalind. You just don't want to cross those lines. If he really wants to be a trustee, Rosalind, then just don't make him a beneficiary. He may be, Betty, but he may not. Okay, he may have passed up that responsibility. Okay, it's a good question, Betty. Even if he is one member of the board, if he's only one of 7 votes, then this may or may not fly. That's a question for your estate lawyer. Okay. She's not the settler of the trust, Alicia. Because she's not the settler of the trust, I don't have that revocable concern. Okay. It's really that Dennis is the settler of the trust. That's what creates that revocable concerns. Good question, Alicia. Thanks. Yeah. Okay. So first off, there's no tax advantage here. Okay. Between TOSI and our regular attribution rules, all the dividend income will pass to Dennis. Okay. And this is due to TOSI. Okay. And to our attribution rules. So we cannot use this to sprinkle income. We used to do that. At one time, you would use this kind of trust as an income sprinkling tool. And just like I showed on the last slide, the difference being there, everybody was dead and we didn't have a small business. Here, Dennis is not dead and we have a small business, which means TOSI applies and we can't just sprinkle income. Okay, that's all good. So why did I do this? Well, what this allows us to do is much the same as on the last slide, to kick a certain planning can down the road. So what's going to happen here is at some point within the next 21 years. Why within 21 years? So I don't have to deal with the 21-year rule. At some point here, the trustee figures out which kids, okay, or none, it might be none, are Dennis's heirs. Okay, who's actually going to run the business? And that's where we would allocate probably the common shares. And I'm not saying this is exactly how this is going to work, but maybe what you do then is allocate common shares to the successor or successors. Okay, and maybe you allocate preferred shares to the other kids. Say something like that. And what that allows us to do then is to just wait to figure out where we're going to have ownership of the business. Okay, if no child sort of materializes here, if no child steps up as the successor, then we probably sell the business and distribute the assets to the kids. If I don't do it in 21 years, then I have that deemed disposition, and it's going to be hard to pay that tax, isn't it, Todd? It's going to be tough to come up with enough cash to pay that tax. So yeah, you do want to do this within the 21 years. So if no child steps up, then we're going to sell the business and wind up the trust, okay? And then just pass the proceeds to the kids, say, fine, it's not really in the cards for this to be our family business. Okay, now, why did I bring the spouses in as beneficiaries? So I kind of, Alicia, okay, this is a difficult question. I will say that broadly, the lifetime capital gains exemption may be available. However, it's not so simple as to say it would be available. So the lifetime capital gains exemption may be available. And what would have to happen here is the trust sells the business. You with me here, Alicia? Or disposes of the shares. And it would only be kids who have a beneficial interest in the business okay? So for any kids who have a beneficial interest in the business, we may be able to use their lifetime capital gains exemption. So the trust itself doesn't have a lifetime capital gains exemption. The kids have lifetime capital gains exemptions. Their spouses have lifetime capital gains exemptions. That's why I bring the spouses in, honestly, is because it gives me more lifetime capital gains exemptions to use. Okay. But this does require good tax advice. And this is sometimes done very sloppily. Okay. So this has to be done properly. But yeah, you can potentially multiply the lifetime capital gains exemption by the number of beneficiaries. Okay. And you see that strategy used quite a bit in farming. That's why this is so popular in farming communities. Okay. That's good. Bev, that's a true story, right? Get farmers using this to try and multiply their capital gains exemption. Why not? Bev, what's wrong then? What's the kind of here? Or is it just not that common? Is that what you're saying? I think it depends where you are too. Okay, I know sometimes people don't like to bring in the spouse. Honestly, I think you should, Bev, and the reason that I think you should is because you're going to give this beneficiary or the trustee absolute discretion. Okay, so the trustee has absolute discretion over this thing. I'm not going to have any fixed interest. Okay, and because I have absolute discretion, okay, because I have absolute discretion, this means that if the relationship ends, and that's going to happen, Alicia, right? I got 3 kids here or whatever, they're all married. One of the relationships is going to end. Good. I am assuming that right from day one. Okay. But because it's an absolute discretionary trust, that means no one beneficiary has a fixed interest in the trust. Okay. And because no one beneficiary has a fixed interest in the trust, that means it's nobody's asset. Okay, there's nothing here that belongs to anybody right now. It really belongs collectively to the set of beneficiaries. I'm not going to say it's impossible, but it makes it hard for a successful matrimonial property claim because now you go through this separation and you say, well, I'm entitled to some portion of the farm. Well, show me what portion of the farm or the business you're entitled to. Okay. You weren't going to get a fifth of it. You weren't going to get a tenth of it. Maybe you were going to get nothing. Okay. So this is what you'll see as the feature of these trusts. Okay. Is that we set nobody up with any fixed or contingent interest. We just have a trustee who can make every decision. So this is the opposite of what I showed you with the life insurance trust. Remember, with the life insurance trust, I talked about absolute discretion being a minefield that could potentially come back and bite us. Here, I'm deliberately using absolute discretion because it prevents anybody from having a firm claim to any of the assets in the trust. Okay. And the difference here is that I have a professional trustee. So almost certainly not Esther, right? Almost certainly doesn't matter what the will says. And in fact, one advantage here is that when Dennis dies, if Dennis dies with this trust still in place, none of this property passes through his estate. Okay. And I'm going to show you that more on the next slide. Okay. Are we good here? Now, to Bev's comment, I will generally defer to the lawyer as to whether to bring the spouses in or whatever, but I do want to ask the lawyer, what's your opinion about having the spouses as beneficiaries? Because if I bring the spouse on as a beneficiary, I have a much better tax planning opportunity later on when it's time to distribute the ownership of the business before we hit that 21-year rule. Okay. Good. Okay. And in fact, in a trust like this is what makes this even a little bit more complicated. I don't even necessarily have to tell the beneficiaries that they are beneficiaries of this trust. Dennis could set this whole thing up without ever disclosing to the kids, their spouses, their grandkids, and so forth, that there is a trust here. Okay. That's all good? Okay. Can I erase this? Happily, eh? Okay. Now I'm going to show you what is actually probably the most common trust you're going to run into in terms of the type of work you would be. Now, maybe Henson Trust, maybe the next one is more common. But anyways, quite a common trust today. And this has become common because there are certain types of wills challenges that have become so prevalent. Okay. And we see a lot of estate lawyers today who are frustrated, who express frustration with the sort of volume of wills challenges. Okay. So to your comment earlier, I think Sherry, was it you? Wills have become easier to challenge, and the courts accept more stuff as wills challenges. Okay, and this is especially true in British Columbia. Okay, British Columbia is particularly problematic here. In BC, we have probably the widest open set of potential challenges for wills. Notably, the adult dependent child, right? We've talked about that before, how an adult child who is, independent, who is financially independent can have a claim against an estate, and we really can't do anything about it. Okay, that's not just true in BC, but BC is this and other reasons much more difficult for the will. Okay, so here's my scenario. We're going to have a little scenario here, and I've got Diana here. Diana is age, we're going to make her 67. Okay, and she has assets. All right, she has kids from her first marriage. Okay, and she is recently remarried. Okay, so we've got her new partner here, Alan. Okay, and he doesn't have much in the way of assets, but he also has kids from his first marriage. Now, these kids are grown up and independent, right? Everybody's grown up and independent here. So Diana says, all right, I want to make sure that the following happens. She says, if I predecease Alan, when Alan's a little younger, we'll make him 59. Okay, so Diana says, if I predecease Alan, that was hard for me to do. If Diana predeceases Alan, then she wants him to be taken care of. And if he's not, then he would just file a dependent relief claim against her estate. Okay, but she doesn't want all of her stuff to go to his kids. Is that a fair outcome? Do we get that? Okay, she wants it to go to her kids. Now, you can try to do this in a will. She can write what's called a mutual will. And the mutual will creates an obligation for Alan to treat Diana's property a certain way, but mutual wills don't tend to hold up. They're not a great resource. So she's going to come up with a probably better solution here, okay? And it's a trust, as you might expect. So what she's going to do here, she's going to set up what we're going to call a joint spousal or joint partner trust. In this case, they're married, so it's joint partner trust. Okay. And she's going to settle whatever assets she's concerned about into this trust. Now, she can't do this with her RSP or RIF or whatever. So this is going to hold non-reg assets. Might hold her house, maybe. That's a tougher one. There is a way to do it, but we have to be careful with it. Vacation property. Okay, if she has any business assets, that kind of thing, all that stuff is going to sit in this trust. Okay, that's good. And we'll call it the DNA family trust, or sorry, DNA spousal trust. Okay, easy enough. And now she is going to name as what we'll call our income beneficiaries or our life interest beneficiaries. Okay, and the language here varies. It's really province by province, and to some extent even the lawyer's preference. We're going to name Diana and Alan. Okay, and what that means is that as long as one of them is alive, the trust will take care of them. Okay, everybody's with me here? Now, normally, yeah, I'm going to get to that in a second, Todd. It's the crux of the problem. You're right to ask it. Just bear with me for a second. So then, normally, when I do this kind of thing, when I set up the trust, I have a deemed disposition of property. Would everybody agree with that? We saw the deemed disposition of property settled into a trust on the last couple slides. It's a true story, isn't it? Okay. But who is Diana settling this trust for? Who's the beneficiary of this trust? Okay, her and Alan, right? Are the kids beneficiaries right now? They're not. It's only her and Alan, right? Okay. So if Diana gives property to Alan, just forget about a trust for a minute, okay? Forget about the trust. If Diana gives property to her spouse, is there any disposition there? I just had that on the last slide too, Esther. Why can't she be the beneficiary of the trust? No, there's no disposition. We can always have a rollover of property between spouses. Okay. Okay. Always, always, always. Yeah. On non-reg too, Todd. Absolutely. Yeah.
You can't, even if his name wasn't on the non-registered account, you can still roll that over.
100%. Yeah.
And there's no tax.
Hang on a second. There's no disposition. Okay. However, there would be attribution if it was an income generating asset.
But I mean, let's say she had an asset non-registered that she put in at 50,000. Now it's 100,000.
Yep.
She dies and it's only in her name. There's a $50,000 taxable gain that's got to go on her taxes. No.
Nope. She doesn't even have to die for that to be true. So she could give that just while she's alive. She's got that property with that $50,000 deferred capital gain. She can transfer that to Alan on a rollover basis.
Yeah, and after she dies, she can still do that.
Right.
Huh. I didn't think that's how that works.
Yeah. Any property from spouse to spouse, anytime. Okay. So Esther, it's the same tax consequence. Do you see this? With or without the trust. Okay. So with or without a trust, doesn't matter. Okay. Diana can transfer property to Alan with no disposition. Okay. A rollover applies. That's good. Okay. Even a bank account that only has their name on it. That's true too, Todd. Yeah. A bank
But if
account.
one of them, but if one of them dies, they can't access that other account because when they go into the bank, they say this isn't your bank account.
Sure. So that's not a tax outcome, though. That's an ownership outcome. The bank is just going to want to see that you properly are the new owner of that asset, right? The bank is going to want to see some sort of probate documents or something in the will or whatever, right?
Yeah, but I get, and so you're saying there's no probate or nothing on that
No, I
because,
didn't say no probate. That's a different question.
oh,
Okay.
so it's probatable, but the income that's in it or the capital gain that's in it is passed on to the other person, and the dead person doesn't have to pay the taxes on that.
That's right.
Huh, I didn't know that.
Okay. I think you did. I think if you went back to chapter 9, you would see that you did know that. I think you've just maybe forgotten something here this morning or whatever. I think you did, honestly. All right. Okay. Well, so Esther, you can roll it over to your spouse, okay? But it's still taxable in your hands when you get it. So the severance, right, is paid to you and taxable to you. Now it's your asset. You with me here? Now you can roll it over to your spouse, okay? But if the spouse invests it, there's going to be attribution back to you, right? Okay. Now, potentially you can do a spousal loan with it. I don't know the tax circumstances at all. Okay. That's that whole attribution mess, right? And in fact, it's going to apply here as well. All right. Right. But it isn't how do you eat an elephant problem, Esther, right? That's exactly the kind of place where I would draw a line and just lay out what's happening, right? Severance, deal with the severance. Now you have the severance. What do you do with it, right? So just walk through it from A to B to C to D, and then you're not really putting the concepts together. Okay. Yeah, we'll never feel like we know enough. All right. Is anybody here on the Canadian Group Insurance Brokers website? Anybody a CGIB member? I don't think so. Anyways, you just talk about this, Esther, this idea of how much we have to learn, right? And if you do a lot of group insurance, it's really good. It's about $500 a year for a membership. I would say that I got $500 worth of learning in the last 24 hours from their website. So they have a super active Slack channel, really well done. And somebody posed just a fantastic question, maybe Wednesday at lunch, and it's about drug pooling. And there's like a whole, like a PhD dissertation on drug pooling if you combined all the answers that everybody has given. It's just beautiful. It's, I don't know, it's like hundreds of years of group benefits experience and excellent opinions and just lots of data, right? Yeah. All right. It is. Okay. Yeah, but think of this now with like, and this is what happened, Todd, is it's like a dozen different people with that level of knowledge and differing opinions and regional differences and differences by carrier and all that kind of stuff. It's just, and anyways, my point is that he should be in this group. Honestly, everybody who does a lot of groups should be in there. It's just an unlimited amount of learning that can happen. But my point, Esther, is we'll never know enough, right? I'm going to have to read that discussion 2 or 3 more times to really absorb it. Okay. So, anyways. What are you asking me, Bev? Like, are you asking about the renewal rates? I haven't seen, honestly, any controversy at all about STD rates. Have you had a problem there, Bev? You got a group that's suffering with that? Yeah, that's what I'm asking. Have you seen that? Because short-term disability is mostly pooled. Interesting. That's it, because how big is your group? Oh, okay. I mean, I can see that, but short-term disability is such a small portion of the plan. I don't know. I guess I don't think of 8% as being that bad for a renewal, but you're just not used to seeing 8% hikes on short-term disability, right? But that is interesting. See, that's exactly a question that I would ask in there, right? Yeah, I'll ask that question, Bev. I'm curious about it. All right. Okay. Yeah, that is interesting. I'm surprised to see it, I don't know, this early in the year, I guess. It seems more like a prospective increase than a real increase. Okay, anyways, let's go back to trusts. So now, the second part of this brings us back to Todd and Esther's question earlier, and that is, what happens when the last of Diana and Alan dies? And that's the whole point of this exercise. Okay, what happens when the last of them dies? Well, what we're going to have, now we're going to have capital interest beneficiaries. Huh, interesting. Okay. No, I already read it. It's okay. All right. That's all right. So yeah, what happens when the last of them dies? And what's going to happen here is we're going to have what are called residual or capital or remainder beneficiaries. Okay. Or sometimes the remainder men, which is such a great word. And that's going to be most likely that will be Diana's kids from her first marriage. Now, maybe she even does something like this. Maybe she says 80% goes to my kids from my first marriage and 20% goes to Alan's kids or something like that. So she could actually mix it up a little bit. There's no requirement for her to do it this way, but most likely that's what's going to happen. Okay. So now this has accomplished what we want to accomplish. This means Alan is taken care of until he dies. Would everybody agree with that? Okay. When Diana dies, we have a bunch of estate outcomes that are interesting here. When Diana dies, we're going to have no probate because she didn't have this asset as part of her estate. The stuff in the trust is not part of her will, which means we can challenge the will, but there's going to be no effect to it. Okay, assets are going to bypass creditors. There's no reason that her creditors would be able to access any of this stuff. Okay, and it will be confidential. What does that sound like? It sounds like insurance now, doesn't it, Melanie? It sounds a lot like a seg fund, in fact, right? So what I've done here, there you go, Esther, right? What I've done here is I've taken her non-registered assets and I've given them a seg fund treatment or an insurance treatment. Okay. Kind of interesting, isn't it? Now, the other thing that's going to happen here is when the last of Diana and Alan dies, we will have a change of beneficial ownership. Okay, when the last of Diana and Alan dies, so that's going to be a taxable disposition. And that taxable disposition can either happen to the trust or to the terminal tax return. Okay. Any questions there?
No questions. I was just thinking outside of the box again, but you won't like my answer. So
Well, we're already well outside of the box here. You're not saying you're
I
going to
was,
sell everything.
I was gonna say, Jason, why can't you make it something legal where you set up an alter ego trust and somehow you form a corporation and then you also get the small Canadian capital gains exemption on within an alter ego trust. I know you can't do that, but I'm just thinking
you could sort of. You could have a corporation held in here. I have business assets on my list, right?
It's just the way the tax system works. It's like, if you can think of little ways like that, and then as long as the tax guy says, yeah, you can do that, then you can find ways to pay less tax,
So I could have a corporation in here. And in fact, you'll see a lot of combination trust and corporate structures. It is very normal. Those are typically done more with a tax intent than with an estate planning intent. But yeah, that's common enough.
But in the end, you're going to pay the same amount of tax in this or out, right? It's just.
Yeah, this is not going to reduce my tax. This is
probate.
Yeah, and it's going to get the assets where I want them, right? This is really about accomplishing my desired outcome.
It's got some creditor proof as well, right? So
it has some creditor protection. Yeah. Now, Shauna, how long ago did you redo your will? Yeah, I'm not surprised at that. This measure, so the first examples of this, although actually there is a case called Easingwood in British Columbia. I don't know, I can't remember when you moved to BC, Shauna, but if you were in BC, when you weren't in BC in 2013, were you? Interesting. Yeah. Then, man, I think Easingwood was 2011, and Easingwood was the case that kind of blew all this wide open. And I'm sure that was 11. Maybe it was later than that, Shauna. I might be misremembering. But yeah, I would suggest lawyers who are aware of Easingwood were often introducing this kind of thing. Now, the other question, Shauna, is how much assets would your husband have had, right? Because if you're, and I don't want to assume anything here, remember, it has to be enough non-registered assets to make this worth doing. Okay. I cannot what in BC, Todd? What can't I do in BC?
I was just thinking about when you disinherit a child, but then you can do it, but then the child can challenge the will. But I know this is different. This is
right. So now I'm bypassing that whole concern, right?
Right.
Okay. Shauna, there you go. Okay. I'm sure he'll come through one day for you. So remember, what was my other potential concern with my trust? What was the tax minefield that's waiting for me with my trusts? We've seen it on the last two slides, a potential tax complication that's going to arise. So there is going to be attribution, Betty. That's 100% true. As long as Diana is alive, all the income from this trust will be hers. Second death is going to create that tax outcome, but we'll liquidate stuff to pay the taxes there. Some of you knew it on the last slide. There we go, my 21-year rule, right? Remember the 21-year rule? It says once this trust has been around for 21 years, then we have to pay the tax even though nobody has died, right? Okay, that's true for almost all trusts, Todd. So there is no 21-year rule here. And the reason there is not is because Diana, the settlor, which I can't type, is age 65 or older. And she's settling a trust that's only for herself, which we would call an alter ego trust, her spouse, which we would call a spousal trust, her common law partner, which we would call a CLP trust, or some combination of those, which we would call a joint trust. Okay.
What about a dependent adult child?
Nope, it only that very specific set of categories. Okay. And if those things are all true, then we don't have the 21-year deemed disposition rule. Okay.
Why don't you have it?
Because of section 108 of the Income Tax Act.
But why would they put that in there only for this one?
So specifically, nobody really contemplated this trust as a way to bypass probate. That was never the intention. Okay. The real intention here, from a policy perspective, is a trust that reduces the likelihood of elder abuse. Okay. That's really what the policy reason for these age 65 plus trusts are. Because what we want to do here, that sort of, here's how the policymakers envisioned this. They said, I've got Diana, she's 67. She's now getting into this territory where she's more likely to be victim to an elder abuse or an investment scam or whatever the case is. So we want to give her a way to build a layer of protection for her assets, where she's going to have a trustee now, and any investment decision that she makes is going to have to pass through that trustee. And in order to encourage her to do that, we're going to say, go ahead, Diana, set up the trust. We don't need you to have a 21-year rule, because really you're not getting any kind of tax benefit out of this. It's just to give you that incentive to reduce the likelihood of elder abuse. Okay. No, so, I mean, you can shade, but it's going to be subject to the 21-year rule. Okay. All right. Yeah, trustee might be herself. I'm not a huge fan of that. Often it's going to be one of her kids.
But wasn't it set up for elder abuse so one of the kids could siphon money out, maybe, no?
Right. So that's why you might have two of the kids as trustees.
Okay. And then the other thing, the 21-year rule, so that you have to be over 65 when you set this up.
That's right.
So that's the key to this alter ego. And if you're under age 65, you can't, if you set up one of these, then the 21-year rule applies.
Right. And sorry, Shauna, I should have mentioned that. That's why your lawyer wouldn't have talked to you about this, because you're not 65, Shauna, right? Okay. Yeah. Okay. Perfect. Now, when you're 65 or when your husband is 65, Shauna, then you might go back to your lawyer and rewrite everything. Good? Okay. I should have thought of that, Shauna. Sorry, I had to work through the whole thing. See, one bite at a time. Okay. Yeah, that's key here, Todd. Age 65 and only for you and your spouse. Yeah.
That's going to be on the test. So you need to know that.
Yeah, yeah. It's
guaranteed.
It's on the test and it's on the practical too. Yeah.
I can guarantee it.
Okay. So yeah, it would not surprise me. It's I will never guarantee anything like that, but yes, it's a nice bit of information to lock away. All right, all good. And Shauna's question is a helpful reminder of that, right? Shauna asks, why didn't my lawyer tell me about this? Because Shauna's not 65. All right. Beautiful. Can we move on? Okay, so the last, I would suggest they do, Stephen. Yeah. Yeah, I would suggest that's true. Not the same broad spectrum, but it's typical that when you, so if I'm dealing with an estate lawyer, my estate lawyer typically knows some family law, some corporate law, some tax law. They'll know a little bit of like assisted dying law, right? Yeah, I find that that's the case. The lawyers that, and if you listen to the podcast, you'll hear Erin in 2 episodes there, and she talks about, she's an estate lawyer, but she gets into some fairly specific business planning issues, right? Stuff like that. Yeah, I think that's true. I think lawyers tend to be fairly broad in their knowledge. Okay. So my last trust scenario that we'll work through before lunch here is for a beneficiary with a disability. And we are going to have some tax advantages here. There are 2 very specific tax advantages to these kinds of trusts. Now, we don't normally set them up for their tax advantages. They're normally set up so that we can preserve your provincial disability supports. Okay, so as an example, ODSP has a $100,000 asset limit. Sorry, $40,000 asset limit. So in Ontario, if you have somebody with a disability who incurs, I should have invited somebody else to this 10 minutes. Anyways, so if I have somebody with a disability, okay, and that person incurs or inherits more than $40,000, they have, I think it's 6 months to get rid of it, okay, or they lose their ODSP benefit. Alberta has a $100,000 asset limit, H in Alberta. Okay. Now, that being said, I don't know that British Columbia limits low, Todd. It might be 5,000. Just checking real quick here if I can find you an answer in sort of 30 seconds or less. Assets, oh, it's 100,000. 100,000. Okay, 200,000 for a couple. All right. All right. So first thing is, I will generally use the RDSP first, right? So my preference here is generally RDSP first. It's easier to use to protect assets. You don't have to do anything cute to use the RDSP. So we can get up to about $200,000 with the RDSP, and then a trust if necessary beyond that. Okay. So if you can use the RDSP, I would suggest you do. Okay. That's all good?
Does the trust need to be set up before you pass away for something like
Nope.
this?
Nope. You can set it up in your will.
Okay. To
Yeah.
say to set up a trust. Okay.
That's right. And in fact, that's what we're going to see here. So
And then
this would be,
with insurance, you would name the estate as a beneficiary because then it would go into the will, and then the will would put it into the
yeah,
trust.
this is a case where I would not suggest that you would want to mess around with that we talked about earlier. You would definitely want your estate as beneficiary and a good will to support this. 100% agreed, Todd. And part of that would be funding the RDSP first and getting that done properly, and then the rest going into the trust and having a properly established trust. Okay. Good? Okay. Yeah, perfect. So here's what happens. We have the last of mom and dad dies. Okay. And we have a will that establishes a trust for a child with a permanent disability. Okay. And this child is on provincial disability supports. Yeah, the most recent document wins, Carla. It's true. But still, the reason I like to update the beneficiary designation is because if nobody tells the insurer that, Carla, you can still get the beneficiary designation paid to the wrong person, right? Yeah. So we should always have as much integration as we can with our planning. You don't want to have a bunch of different stuff pointed in different directions and then just kind of figure it'll take care of itself, right? That would be the opposite of estate planning, wouldn't it? So yeah, that's where exactly, Todd, you would use that estate beneficiary designation. Okay, the child is collecting provincial disability supports. And remember, these can be quite important, right? It's not necessarily the amount of income. If you've got, oh, and just one other comment here, sorry, to finish out my picture on the top right here. I would suggest if assets are more than about $5 or $6 million, somewhere in that ballpark, then don't bother with what we're going to call the Henson Trust. Okay, that's probably enough money that I don't care about disability supports anymore. I probably can just get by with the assets in the trust. And what you can end up doing here, you could have a ton of assets, but you're so concerned about preserving your disability supports that you put a big handcuff on. We just don't want that. Okay, so the last of mom and dad dies. We got a will and might be some life insurance here. I'm going to introduce the term right away here, Melanie. Okay, I will. Yeah, I know I didn't specifically introduce it, but you'll see it right away. So, and by right away, I mean in like 8 or 9 minutes. All right. So we know that there's going to be a deemed disposition here, as we've always seen. And now we're going to set up this trust. Okay. And as a minimum, I might have other beneficiaries, but as a minimum, I'm going to have at least one beneficiary who was a dependent of mom and dad's at some point. And we can also do this from grandparents. This could be done by grandparents who was a dependent and has a disability. This person likely qualifies for disability tax credit. That's generally going to be required for what I'm going to show you here. So I have now, And whatever assets we have in the trust, I don't care too much about that. Our capital, remember, of the trust. Okay. And I've created now our disability trust. Now, oh, I could do this for great grandchildren too, Bev. Yeah, you're right. I shouldn't dismiss. Oh, hang on a second. Can you? Oh, maybe not, Bev. Don't hold me to that. Don't hold me to that. I might be wrong there. And the problem, Bev, is that my version of the Income Tax Act predates the rule I'm going to show you, so I have to find it in the internet. Okay. I'm too cheap to buy a new version of the Income Tax Act. So, so then I'm going to have a trustee, as we always have, right? And this might be a sibling, this might be a professional trustee, might be an aunt or uncle, whatever it happens to be. The most important thing, as with any trustee, is that it's somebody we trust, okay? This trustee is going to have absolute discretion. What does that absolute discretion mean? If I use that term, absolute discretion, what does that mean? That means they have full control. So that also means then, by extension, that the beneficiary has no fixed or guaranteed rights to this trust. Is that fair? Now, this is actually not true in Alberta. Alberta is exceptional here. Alberta does allow a trust to work where we don't have that limitation. Okay. Perfect, Alicia. Yeah. Okay, good stuff. I like it. Yeah, I buy that. All right. That saves me having to look it up. Okay. So this creates the effect then what we would call a Henson trust. And the reason we call this a Henson trust is because the very first of these was a lawsuit where a parent in Guelph, Ontario, had left this for his daughter, Audra Henson. Okay, so he had died, left this behind for his daughter. There was absolute discretion over it. And the Ontario government, the Ontario Disability Supports Plan, said, hey, she's got a bunch of money now. We're going to cut off her ODSP. And she went to court over it. And in court, the court said, no, she doesn't own those assets. They're in a discretionary trust. Therefore, it does not wreck her asset test for ODSP purposes. Therefore, she continues to qualify for ODSP. So that term Henson trust comes about because you get to bypass the asset test from specifically ODSP. Now, as I mentioned, this used to be allowed in every province except Alberta and Newfoundland. Alberta now allows this, and in fact allows a more generous version of it. Newfoundland does not have legislation or policy supporting the Henson Trust, but practically you can still do it in Newfoundland. Sorry, Newfoundland and Labrador. Good. Okay. We're all happy with that? So that's the big win, right? The big win here is you preserve your disability benefits. Okay. Now, that being said, there are two potential tax advantages that we can use here as well. Yeah, that is quite a big thing potentially, right? There are many scenarios where it's very important that the parents plan for that kind of thing to persist. Okay. All right. So, sorry, my tax benefits here. Okay. So tax benefit number one is what we call the Qualified Disability Trust, or QDT. So here's what I have. I have a trust that was established by will, which we have here. Okay. I have a beneficiary with the disability tax credit, which we have here. And then in each year, the trust files a QDT election. So the trust says this year we are a QDT. And what that allows you to do, it allows the trust to retain income and pay tax using the graduated tax rates. What did I say is the normal tax rate for a trust earlier? How would a trust normally be taxed? Top tax rate. But now we have access to lower tax rates. Does that all make sense? And that sounds pretty good, doesn't it? Because what that would allow you to do, yeah, forever. For as long as you have those other criteria met, Melanie. So for as long as you have a beneficiary with a disability tax credit, then yeah. Okay, now you're only allowed one QDT per beneficiary per year. So you can't have, say, both sets of grandparents or both sets of great-grandparents, Alicia. You can't have both sets of grandparents set up a QDT for you. Okay. There's still a 21-year rule here, Shauna. Yet we don't get away from the 21-year rule. Sorry, Todd. Yet we don't get away from 21-year rule. We're still going to have that issue. Okay. So no circumventing 21-year rule. Yeah, then you have your normal capital gain. And if there happens to be capital gains that tax has to be paid on, then you pay tax on them. Although as a QDT, you're paying tax using graduated tax rates.
Do they lose their disability tax credit at that point?
No, there would be nothing that would cause them to lose DTC there. Unless they actually just were no longer disabled or CRA didn't think they were disabled anymore. Okay. Here's the real issue though. This is what I find to be the biggest problem with this thing is if any of the money that was taxed at low tax rates is ever paid to anybody other than my disabled beneficiary, then we have to unwind all the tax benefits. Okay, good. Basically, you have to go back then and figure out for the history of that trust, what would have happened if the trust had been taxed at the top tax rate and then pay that amount of tax as a recovery tax. Now, this shouldn't generally be a problem. Where it will be a problem, however, is where your beneficiary dies before we could get most of the value out of the trust. So you have a beneficiary who dies unexpectedly. Now you're going to have to pay amounts out to somebody other than the beneficiary because they're dead. And that's going to result in that recovery tax.
What if you had it paid out to a charity? Would that create a huge tax deduction then? Because
you'd get your tax credit, that's true. So you could use that to mitigate some of the consequences of that, but you're still paying tax there. And the question would be, Todd, whether or not the trustee, the charity is actually a beneficiary of this trust.
Okay.
Yeah, so that's a little bit of a headache. Then my second tax benefit is what's called the preferred beneficiary election. We'll just do this, then we'll break for lunch. So the preferred beneficiary election, this is an older benefit. This has been around forever. And with preferred beneficiary election, what can happen here is the trust earns some income that would be taxable. It retains that income, okay, but it passes the tax consequences on to the beneficiary. Okay, and this would be quite attractive to take advantage of, say, disability tax credit. If I have a beneficiary with no income, exactly that, that's exactly the point here, Todd, right? You've got a $13,000 basic exemption. You've got about a $9,000 disability tax credit. That's $22,000 of income that can be tax-free. Okay. Good. It's a much easier rule than the QDT, and yet I don't see it done very often. Now, one of the challenges with it is that you would have to, it's going to show up on your notice of assessment. So you would have to explain to your caseworker under whatever disability benefits you're on that this was only a gain you had on paper, and your caseworker is going to want to see bank accounts to demonstrate that you didn't actually get the $22,000.
So can you go over this again, Jason?
Just the preferred beneficiary election?
Yeah, like, so instead of just having a regular beneficiary, you're saying you name it as a preferred beneficiary? Or
In the Income Tax Act, the ability to do this is referred to as the preferred beneficiary election. So,
and so you're saying the money isn't paid out to the person that's collecting the disability tax credit. The money is staying in there. He's just paying the tax on it.
Yeah.
So it, on paper, he's saying he's making 13. Let's just say it was 13,000, or let's say it was 22,000. But then he claims the basic exemption, the disability tax credit. He claims the 22K, but really he's not getting the money, but he's now paying the taxes on it.
right, which is going to be nil tax, right? So yeah, you can see how this is a good deal, right? And it's a much simpler arrangement than QDT. I would be jumping to the preferred beneficiary election before QDT. I find the QDT quite complicated, and potentially, because you may have to actually repay all those benefits at some point, just don't know that you would catch me using it. Okay, yeah, we're getting there, Todd. I don't think anybody is inherently good at trusts. I don't think that's a thing.
Well, I should know it because I learned it a long time ago, but when it came to the trust part, and I remember on the exam, I basically just marked C for everything and moved on.
Yeah, I mean, yeah, the thing to do with trusts is to just first ask yourself, what would happen if there was no trust, right? And on an exam, probably half the questions are going to be answered just by the answer to that question. Just pretend there's no trust and now answer it.
Tax is the same.
Sometimes, yeah, that's right. The taxes, other than these narrow circumstances, right? Other than the 21-year rule, QDT, preferred beneficiary election, the tax is pretty much the same. Yeah. Okay, that's good.
One last thing, if you set up something like this for somebody that's disabled, and let's say they were over the age of 65, does the 21-year rule still pertain? Or remember in the other example you said
No, because remember that one you have to set it up for. So that was an intervival. I guess, okay, yes, in theory, if I had somebody who's 67 and they set this up for their 64-year-old partner who has a disability, that person dies. So remember, it has to be a QDT, has to be set up by a will. Preferred beneficiary election, it just has to be somebody related to you. Okay. It wouldn't be alter ego, Betty, because At least not for QDT, right? Because you have to die. I can't die and set up an alter ego trust because I'm gone.
Because I'm just thinking if you had I mean, I guess I'm thinking of like a couple or an adult child, and then
You
what-
can't do it for an adult child. Okay. It would have, because remember, for the age 65 plus rules, it had to be age 65 plus and set up exclusively for the benefit of you and your partner.
Okay, but if you were a couple and let's say the husband's permanently disabled,
Mhm.
they wouldn't set it up as this. They would still set it up as an alter ego, I guess.
Generally, yes. And especially because if you're over the age of 65, likely your spouse is close to that age, right? And once you're 65, you're not collecting your disability supports anymore. So why would you bother setting all this up if you don't care about disability supports, right? Those
And
supports end at 65.
If that's called an alter ego, what is this called?
A Henson Trust. You would normally call this a Henson Trust, which is not a term in the Income Tax Act. There is nowhere in the Income Tax Act that refers to the Henson Trust. However, across the country, pretty much any time you refer to a Henson Trust, everybody is going to jump to a trust for a beneficiary with a disability. Good? Okay. All right. Any questions before we break for lunch? That is it for trusts. Once again, that's everything I know about trusts. Okay. Perfect. Now you don't have to use a trust, I guess, Esther, right? Okay. Perfect. Let me stop the recorder. We'll, what time do we have here? 3 minutes to. Let's take a 45-minute break. And we'll resume at 42 minutes past. Okay, we'll see you back then. Thanks. Oh, I'm going to stop the meeting. You're going to have to rejoin, all that good stuff. Okay, thanks.